Hi everyone. Hope
Hi,
we're hope everyone is well. We are there we go. So we are bang on 6, so we might get started. Um, I will pay attention to the chat today, but please sing out if the chat's going off and I'm not um, picking up on what people are commenting. Um, this week we are looking at lack of capacity, undue influence, and a lack of knowledge and approval. Before we jump into today's tutorial question, just a couple of housekeeping reminders. I believe that the census date is coming up next week. So if you are considering withdrawing from the subject, that has to be done by the census date. You may have seen in the welcome video that the general discussion and Q&A forums on the Moodle platform, I've been able to activate those. I had some feedback that these are sort of useful sort of a useful forum for students. We don't have a Teams chat this semester, but we do have these forums. So the general discussions forum, that's really just for interaction between the cohort, interesting cases, queries, that sort of thing. If you've got specific questions, please use the Q&A forum. I did make a note though that I do prefer people to bring questions to the tutorials or email me. The reason for that is if you email me, I'm able to make sure that this is shared with everyone and that things don't get missed in the forums. But I will keep an eye on the Q&A. So hopefully people are happy with that. I've also been advised that potentially some of the reading references in the notes don't align with the textbook. Are people finding this, or how are we placed? Pop it in the chat or let me know. If we are finding that there is a bit of disparity between them, I will have to do a bit of a review, but I think they should largely be correct, but do please let me know. So look, this week, just quickly, overturning a will on grounds of a lack of capacity, undue influence, or a lack of knowledge and approval and suspicious circumstances. This is quite a big week. There's lots of readings and cases. And I will say there's a lot of overlap, particularly in practice. You'll find that a number of grounds are often pleaded. So you might plead that the will is invalid due to a lack of capacity or undue influence. So they're often combined. So some of the cases that you're probably looking at in the readings and your own research may refer to a number of grounds that the will is being challenged on. So just something to be aware of. It is a big week. So before we jump into the scenario, just I'll open the floor for any general questions or comments that people might have that they want to bring to the floor. Nope. Take silence that we're all good and happy to jump in. All right, so this week's scenario, and I should say this scenario, it's similar to the types of scenario that you might be provided in the final assessment piece. And this scenario, I think, is somewhat typical of some of the client appointments that you might encounter in this area of law. So look, I'll read it out in case people haven't had the chance to review it and they're just jumping on. So in this scenario, Bob and Jill have been in a de facto relationship for approximately 6 years. They maintain separate residences, but they have a joint bank account and see each other regularly. Jill doesn't work and assists with Bob's care as he suffers from prostate cancer. in the last 6 months, Bob's been given the terminal prognosis and his health has rapidly declined. Bob is very grateful for Jill's help, and when discussing their future, Bob makes comments that he wants to ensure that Jill is looked after and has a roof over her head. Bob is rushed to hospital late one evening as his health continues to deteriorate. Jill is notified and she also contacts Bob's close friend, George, and Bob's son, Trevor. Bob and Trevor have not spoken in many years, and Trevor is a successful investment banker. Jill, however, feels that it is necessary to let Trevor know what's happening to his father. So one afternoon, Jill comes to the hospital to visit Bob. When she walks into the room, Bob, Trevor, and George are all sitting talking, and she hears snippets of the conversation. George says to Bob, "We will make sure the will is sorted." The next day, Jill comes back to the hospital and is told she is not to go into Bob's hospital room as he is in the process of preparing some documentation. Jill respects Bob's wishes and waits outside. Shortly after, George comes out and asks Jill to withdraw $220 from Bob's account and put it in an envelope for him. He says it's just for the solicitor's fees, nothing too important. Jill fulfills this request and comes back to the hospital later that afternoon with the money. Sadly, the next day, Bob passes away. 3 weeks later, after his funeral, Jill is provided with a copy of what appears to be Bob's last will. In this will, he's appointed George and Trevor as his executors. Jill has been given a pecuniary legacy of $20,000, and the balance of the estate has been gifted to Trevor and George. When she reviews the will in more detail, Trevor has acted as one of the witnesses, along with a woman by the name of Cindy Looper, who appears to be a nurse working at the hospital. Jill can see that the will has been prepared by a solicitor's firm, Wills R Us. Jill asks Trevor when this will was prepared and how, given Bob's current state of health. Trevor advises that the solicitor was able to do it all over the phone, which made things very easy. So Jill has come to us for advice, and we've been asked to identify and explain any issues arising from the scenario, and also to identify any further evidence that we might need to provide Jill with a fulsome advice. So, do we see any red flags in this scenario? Hoping to see some nods.
I was going to crack at everything.
Sorry, I had a few people. I think Bill,
no,
you can start us off.
Go. I think Renee or someone else was having it.
Well, who wants to go first? Someone put the hand up and you can start us off. Ella. Thank you.
I was just going to say that it wasn't signed, executed correctly. The correct witness, I guess, someone who was named in the will was used as a witness.
Yep.
Yeah.
Absolutely. That's one red flag. What else is happening in this scenario?
It was also done over the phone.
Yes. Yep. Absolutely. Red flag there. Bill, do you want to jump in?
I was just about to say the same thing. Section 11, subsection 2, the disposition to Trevor is void to the extent that it concerns the interested witness or a person claiming under the interested witness. So it's void on those grounds, or can be void. To disprove that, section 11, subsection 3C, the court must be satisfied that Bob knew and approved of the disposition and it was freely and voluntarily made by Bob.
Yes, so there's definitely some witnessing issues
with
the major beneficiary.
And of course, the solicitor is not taking instructions and preparing this and drawing this up in person. So that's a big red flag.
Yes.
So he hasn't had an opportunity to prepare file notes, to observe the test data, get any medical reports or anything else. But
Yeah.
I would
Yeah.
have a crack at, I would challenge on the grounds of all those different topics that we're looking at this
Bill,
week.
I'll pause you right there because we will get there, but there are a few more red flags that I think we need to identify. Talitha?
I just sort of thought, we don't actually know what the size of the estate is. So he's obviously provided for her the $20,000. So I mean, obviously in the case of like law school, like it's going to be a red hair, like, you know, we know there's going to be all these issues to counter. But I would think in practice, like the first step would be to go, how much are we talking? Because it could, all of those things could 100% be true, but also like he might only have like $30,000 and she's getting 20 of it. So like for me, I like my very first like step was find out how much the estate is worth and whether it's worth fighting over before you go to the next step.
Yes. Look, absolutely. If we're putting our very practical hats on, we need to know that there's something worth fighting over. So I completely agree. And you would absolutely do that in practice. Let's assume that there's something decent to fight over because we will need to have some sort of answer to this question. But absolutely, we need to know. We don't know what's in the estate. And I think that almost sort of builds on Bill's point that there isn't any file notes that we can see. So we don't know if that's even been discussed with the deceased. Reese, I think you might have been next.
Yeah, a few other things, not terribly related to capacity and
Okay.
UE and whatnot, but the fact they're in a de facto relationship, have a joint bank account, and she assists Bob with his care. I wondered whether that might relate to her being able to claim under the family provision.
Okay. As a de facto, assuming that they've been in a relationship, they've got joint assets together, arguably she would have standing, to make a claim for further provision from the estate. So that is something to always consider. Probably for this scenario where we're focusing on the validity of the will, in an exam situation, you could probably comment on that. You probably focus a little bit more on the subject matter, but relationships are very important generally because you need to know who's who in the zoo. So Reese, no, good observation. Ian?
I was just going to say there'd be a big question of his capacity, considering he's elderly, he's in hospital, and he died the next day.
Yes.
And if it was me, I'd want to be seeing the original will that was sworn for that one and see what the big changes were and why.
Yep, absolutely. So we know he's very unwell, and he died the day after the will was prepared. So all very relevant. Belinda? Oh, Belinda, I think you've just popped yourself back on mute somehow.
There we go. I think one of the big flags big red flags for me was the significant departure from his provide significantly for Jill, provide a roof over her head, and now all of a sudden that's been significantly reduced. So that kind of sets off some alarm bells.
Yes, absolutely. So there seems to be a real departure from perhaps a long-standing testamentary intention, which is to provide significantly for Jill. Absolutely. Ella?
I was just going to say, can we necessarily argue that somebody doesn't have testamentary capacity if they are unwell? So just because they have poor physical health doesn't necessarily mean that they're going to have lack of testamentary capacity. So he could have had prostate cancer, but still have had testamentary capacity.
Yeah, absolutely. So I think we've. Sorry, Reese, did you have anything further to add?
Sorry,
yeah.
The circumstances around which he made that last will, so the fact that he made it at last minute, capacity is obviously going to be hard to disprove because prostate cancer doesn't affect your brain. But yeah, the circumstances around it, so the timing around the making of the last will is certainly an issue.
Yep. Belinda?
Oh, sorry, I've still got my hand raised from before.
No worries.
Just on that point, though, prostate cancer is incredibly painful, so he's more than likely on some sort of morphine drip, and it would certainly affect his capacity. You'd need to get a report from the doctor, wouldn't you, I suppose?
That's right, Ian. We could circle back to medical records there.
Yep. Now I'm just checking the chat. We can assume that there's a residence, quite potentially. He could have nothing. Yep, absolutely. Sorry, Talitha, I think you've already spoken to this point. Equity, we'll park equity for now. So I think that's heading off on a different track, but quite potentially. The point of this exercise is really to highlight that there's a lot of things that raise red flags, but those red flags need to be investigated. And just as Ella touched on, for example, just because someone is unwell and suffering from cancer doesn't necessarily mean that it's going to impact on their testamentary capacity. Angela, I can just see you've got your hand up.
Yeah, sorry, I just got my daughter in the background tonight.
That's okay.
The other thought I had was in regards to that $220 she was asked to withdraw, and then you've got a nurse that actually witnessed that will. Was that a part of a bribe of some sort?
Okay, yes. So
does it be suspicious because we haven't got an invoice and we haven't received anything else or other communication as to the rationale behind it?
Yep, absolutely. So it really demonstrates that we need more information, because a number of different conclusions can be sort of drawn from these facts. So I guess...
Arabella, it's only $220. Now, how come George doesn't have $220? Is there something we're missing there?
Quite potentially. So we need to dig a little deeper. So we've been asked to advise Jill. So Jill's our client. And we've touched on this already. So potential lack of capacity. So if we're advising Jill in relation to a potential lack of capacity, what's our starting point? What do we need to prove if we're going to go down this route?
Is that the Banks versus Goodfellow? Sorry, Banks and Goodfellow?
Yep. So our starting point is, apologies if you can hear my dog in the background. Our starting point is that a duly executed will, rational on its face, is that of competent testator. And that then assumes that the four limbs of Banks and Goodfellow have been complied with. Ella, have you got a thought or question?
I was just going to say that we need to provide significant evidence to rebut the presumption of due execution.
Yes. So we would need to be able to demonstrate that or provide evidence that the four limbs have not been satisfied and that there is a question of the deceased's capacity. So looking at our set of facts, what might we be able to rely on as evidence that the deceased may not have had capacity, do you think? Ella, not sure if your hand's still up or...
Oh, sorry. That was wonderful.
That's fine. Jason, I think you jumped in. Sorry.
Oh, I was going to say, obviously, the doctor's reports, if there presumably are any, but I thought the other person in the room was apparently the nurse. Now, I'm not sure. She's obviously not a doctor, but her observations might be useful. And that's also when we get to undue influence.
Yes. Yep, absolutely. Angela?
It would also be interesting to have a talk with the solicitor who did supposedly take instructions on the phone to see whether he did actually take the instructions from the deceased or whether it was communicated through others. I mean, not ideal situation, but sometimes potentially that could be a place where that could happen, given the medical circumstances they're around. And the other thing would be the death certificate.
Yep. So a good starting point, as Angela has just touched on, is reviewing the death certificate to see exactly what the cause of death was. Bill, yep, you've just popped in the chat. We'd be requesting a copy of the solicitor's file note for the will. That can be very useful, particularly in determining whether or not the 4 limbs of Banks and Goodfellow have been met. Copy of the treating general practitioner's medical records. So medical records. Medical records can be very useful in practice as well. If a social worker, for example, has attended on the patient, sometimes their notes can be or can speak more to testamentary capacity than the medical notes of a doctor potentially, but you'd absolutely want to get that information. So we would be advising Jill, we need the solicitor's notes. We would be looking for the medical records. We'd be looking at the death certificate, because that would really help us to determine whether or not there is evidence to support a lack of capacity. Any other thoughts around what else we might need or anything else that jumps out at you?
I would also find out, ask some questions to the solicitor on whether he has other family members, what his assets are. Well, I think we already covered that. And just asking those basic questions. Why have you, when the solicitor was preparing the will, why have you chosen to do this and dispose of your assets in this way? And are these your final wishes?
Yep. To see if there's evidence of that. Reese, yep.
Going back to documents, whether he's got a previous, whether this is entirely removed from his previous will.
Yep. And we know from the scenario too that he's previously said to Jill, I want you to benefit, I want to look after you. And assuming that he has a reasonable estate, $20,000 may not really actually be sufficient. Ian, yes?
Yeah, just on that, if she was that suspicious of everything and you had all this information to get, you could suggest a caveat to the Supreme Court to stop the probate.
Yes. So jumping ahead a little bit, but just to put it in context for today, if you do have concerns about the validity of a will, and you know that that will, or you suspect that that will is going to be admitted to probate in common form, you can file a caveat in the Supreme Court registry, which basically stops the grant of probate being issued. We cover it a little bit later, but it really protects the person challenging the will from a grant of probate being issued without them knowing, and in circumstances where there is evidence to suggest that it may not be a valid will. So it really just protects the challenger's right, I guess. So yes, absolutely, you could file a caveat if you were concerned. Great. So there's a lot of things that we would be asking for. There's a lot of red flags around the issue of capacity. So we would be advising Jill that she really does need to get more evidence. But certainly, I would argue on the face of it, there's certainly enough red flags to potentially challenge that presumption that the deceased had testamentary capacity. But you would obviously want to back that up with all of the evidence sort of and investigations that we've discussed. Great. So we've also mentioned undue influence. Now, undue influence is particularly difficult to prove. And you'll find that there's not a great deal of case law. And undue influence is often pleaded with other grounds because it is quite difficult to prove on its own. Ella.
Wasn't it touched on in contract law?
It probably was. Yep. Probably was touched on in contract law. So I'm not familiar with the contract law syllabus, but I imagine that it's probably something that's touched on. Ella, what are your thoughts in relation to undue influence?
I was just going to say how, when Jill went to the hospital, George was it George that was in the room with Bob? So obviously when the solicitor has taken their instructions, somebody else has been in the room. So I guess that's also another potential for undue influence, because when taking instructions from a client, you should always take just their instructions and not have anyone else in the room that could interfere, as well when he's being named in the will.
Yes, absolutely. So here we've got a potentially vulnerable will maker. And it appears that at the time he was providing instructions, he had a major beneficiary in the room with him. So definitely potential for undue influence to arise there. Jason.
Yeah, I guess I was just going to follow on from how hard it seems to prove, in the sense that, just because you have the opportunity to exercise that influence, that's not enough to prove the allegation. Yes. And, you need to have this sort of unbounded influence, that coercion.
Yes.
And sort of the commentary as well, like the scope of that coercion changes as well, depending on the circumstances.
Yes.
Like a person at a late stage in their life may require much less influence to get that result. So yep. I thought that, the evidence, that the woman in the room who signed off on the thing, the nurse, her observations in that context might be useful.
Yes.
Otherwise,
absolutely.
It would be impossible to make out, I would think.
Yep, absolutely. And Jason, you've hit a really crucial point there, in that there can't just be, if you are seeking to prove this, there can't simply be a suggestion of undue influence. There must be, I guess, actual coercion. And the other key point is that it really does depend on the circumstances, and the court really must look at the circumstances and the facts as a whole, as to what will amount to undue influence. So Jason, really, really good points, and also really demonstrates how difficult it can be to prove. The nurse, or the other witness, Cindy Looper, I think it was, you would absolutely be wanting, you'd be advising Jill to get a statement from her as to what she observed, the conversations that were had, the interactions, not only between, I think George was in the room, George and the deceased, but also George and the solicitor on the phone, as much information as you could. Great. Thanks, Jason. Any other? Oh, Ella, yes.
Sorry, I was just going to raise on that point. So I guess that's where it would be so crucial to have Cindy's file notes, because what if, or I guess observations, because if she said, oh yeah, I observed that, George pulled a face at, Bob, and then Bob changed his, you know what I mean? Like if he said something and then it changed his decision,
Yes. Yeah.
But you can't establish that without having that actual physical observation from that person.
Yeah, absolutely. Is there anyone else that you think we might want to get statements from?
Did we mention the wife that she was told she was going to be given the property?
So we'd talk to Jill. We'd absolutely get a statement from Jill. And I guess you would also get a detailed statement from her, canvassing what she observed and the relationship between George and the deceased, and her encounter, being asked to wait, not come in. Yep. And the previous discussions that she's had with the deceased. Absolutely. That's all very relevant.
Would you get a statement from Trevor as well? And even just asked about the relationship between the parties?
Yes. Yep. I would suggest that. Absolutely.
Would you essentially be comparing their stories from, obviously what the nurses said and also statements from those two people, George and Trevor?
Yeah. So you'd be seeing if sort of any evidence could be corroborative in nature. I would also potentially see if there were any, so again, looking at medical records, but if any other doctors could provide statements around the relationship that they've observed, the comings and goings, any other discussions that they have had. I think this, again, it really varies on the circumstances in which you find yourselves. Sometimes doctors are quite reluctant to provide these types of statements. Similarly, social workers, you'd be asking for a statement from a social worker that was perhaps involved with perhaps end of life care. Presumably if he's very unwell, they may have been having these discussions. And that's the sort of information that you can pull from medical reports as well. Emma?
You could also get expert advice if you actually got some advice that said, something about the way he was medically and how much morphine and pain medication, opioids, etc. he was on, whether or not that would be likely with the actual amount of medication he was having, dosage-wise, whether that would affect his cognitive ability. And if he died the next day, it's quite likely that he was end-stage palliative and that his doses, he was not of sound capacity to make such decisions of.
Yeah, so more going towards or challenging the will on grounds of lack of capacity. Absolutely. Yep. No, you'd be wanting that expert advice if possible. Okay, great. So hopefully we can see with respect to undue influence, it can be difficult to sort of identify exactly what we need. And I guess sometimes the difficulty around finding the evidence we need to support our concerns ultimately. So then finally, looking at a lack of knowledge and approval, what do we think in this scenario? Do we think that Jill has grounds to challenge the will due to a lack of knowledge and approval?
I feel like, again, you're just going to be relying on the observations of other people because it is so difficult to prove. Not knowing, I mean, he was present in the room, but does that necessarily mean that he gave approval to it and had a detailed knowledge of what, was in his will?
Yeah. So I think potentially in this, Jason, yep. Sorry, I'll go to you first.
I guess there's just so many circumstances though that in this particular one that I thought, should have the best chance under the suspicious circumstances, Lim. Like, I think that I saw at least three, like essentially no apparent estrangement of the testator from a disinherited beneficiary. You could argue she's essentially been disinherited from his previous statements.
Yes.
Control of the testator by a favoured beneficiary. Well, the beneficiary wasn't, well, the favoured beneficiaries who became beneficiaries were essentially in control of him in the room. And where those beneficiaries participated in the making of the will. So I think that there's a lot more to it, but that, as I understand it, puts the onus on the beneficiaries to basically prove those who are propounding the will that it should be upheld.
Yeah, great. So I think that's the, again, sort of the key takeaway. So there's a presumption, that the testator knew and approved the contents of their will, but where the person challenging the will, so in our case, Jill, can raise all of these suspicious circumstances, that then means that the presumption potentially can be rebutted and the onus falls back on to the people propounding the will. So in this case, Trevor and George, to clearly prove that who's our deceased Bill knew and approved the contents of his will. So the onus is flipped. Emma.
Just one quick thing I thought of was wonder if there was a medical directive or a enduring power of attorney. That's something I never really thought of until now.
How do you think that might come into play in this scenario?
Well, it possibly would mean that someone, if he was lacking capacity, that actually be able to step in and take control of his affairs.
So an enduring power of attorney, so an attorney appointed under an enduring power of attorney, pardon me, they do not have standing to prepare a will for an adult. So they couldn't prepare a will, but potentially, are you thinking that there might be a conflict if George or Trevor have been appointed as attorneys and are now?
Definitely.
Yep. Something to consider. And I guess you'd also, and I guess it's not covered in the scenario, but you'd also be looking to see whether or not perhaps the deceased prepared an enduring power of attorney around the same time, potentially. But again, remembering that there's different tests for capacity there. Yep, always good to consider that. Any other thoughts in relation to this scenario and what we might be advising Jill?
I guess it's more of a question I was going to ask when I got into this. Bill earlier mentioned Section 11 of the Succession Act, and the question is, how does Section 11.3c tie into this this issue? Because I felt like there's the cases and everything that talk about this stuff about suspicious circumstances, but Section 11 seems to be saying the same thing. Like the court has to be satisfied the testator knew and approved of the disposition and it was made freely and voluntarily. So I guess I was wondering how they relate to one another.
Yep. So I guess the fairly similar in that you'd be raising the same evidence to disprove either at the end of the day. So you need to make sure, and I guess too, in this case, you're dealing with someone potentially who doesn't have capacity and suspicious circumstances have been raised. Whereas Section 11, you're really dealing with someone that's made the will and may have been able to expressly approve the disposition. They knew that this person was witnessing and they've acted accordingly. But in both cases, you could arguably raise the same red flags and issues to support your position. Does that answer your question?
Yeah, a little bit. So I don't need to, because in my answer, I wasn't sure if I needed to essentially mention both, and that, the evidence is seems to be answering the same thing.
Yeah. Yeah. Great. All right. So just to, oh, sorry, Bill. Yep.
I was just going to say that if you could prove and demonstrate estrangement between Trevor and Bob, then that may go a long way to demonstrating lack of knowledge and approval.
Potentially.
When you go through the Knock on Austin checklist.
Yep. And I think to the very fact that there is this significant estrangement between a father and son, we'd obviously probe a little bit more about that. But there's this significant estrangement between a father and son. Arguably, the son, you know, it appears from this scenario that he's in reasonably good financial circumstances. You know, he's a banker. To me, a red flag is I'm going to leave my estate to my estranged son who's doing quite well, when I've got my partner who I wanted to take care of and I've expressed that I want to take care of, only going to give her a 20 grand gift. So to me, that absolutely raises a red flag. And you would delve more into that estrangement and that relationship between the deceased and the son. Yep, absolutely. So to play devil's advocate a bit, if you were a solicitor and you'd been asked to prepare this will, what would you have done, or what would you have done differently to what appears to have happened in this scenario?
This was touched on earlier, but it's done over the phone, whereas the will has to be done in writing.
Yep. So you would be there. When you say done in writing, you mean you'd go there and see the person?
Actually, was there a note in one of the study guides that it can be done over the phone, now that I think about it?
Look, again, depends on the circumstances. But I think in this case, where you're presented with a client that's, you know, we don't know if he's elderly, but let's say he's very unwell. You're being contacted potentially by a third party. I would be very, very cautious about taking instructions over the phone. As Alison's popped in the chat, you would want to be there in person, absolutely, and have no one else present. So agree, you'd want to make sure that no one would be in that room with you when you were taking instructions.
Especially the beneficiaries.
Yes,
yeah,
absolutely. Ella?
I was just going to say, like in the first instance, before taking any instructions, I would say, okay, I want a letter of capacity. I want to check that you have capacity to make this will. And then, I mean, it's so easy given they're already at a hospital.
Yep.
And then that way, I guess, before you take instructions, you can guarantee that you've covered that area. And,
yes.
you know, given he's in hospital, he's of poor health, it's more of a reason to do that capacity assessment.
Yeah, absolutely. Reese?
Just from a practical point of view, based on what Ella said, would you actually would you do that in your profession, Arabella? Would you get a letter or something confirming capacity if you knew that, you know, he had prostate cancer and was nearing the end of his life, but you had no other suspicion as to his lack of capacity? Would you actively seek that he had capacity, or would you just take it?
If I knew that he was in hospital, I would assume that he's on a lot of medication, so I probably would, out of an abundance of caution. And look, I'd probably have the conversation, well, I would attend in person, number one. I'd have that conversation with him, and I would be saying to him, so that we can avoid challenge, and if there is a challenge that we can prove that you had capacity, I want to get a medical assessment. So I would personally, in these circumstances, I mean, it really does depend on your on your set of circumstances, because I absolutely agree. Just because someone is in hospital doesn't, and if I met with them, they knew what they wanted to do. They could really clearly define what was in their estate. They knew who they should be providing for, family dynamics. If they could provide me with all that information, and like perhaps they'd broken their arm, would I get a medical assessment? Probably not. But if they're in there with an illness that even could just slightly raise that red flag, I would. Yeah, I would. I'll just have a check in the chat. So Bill has raised some commentary from Ryan and Dalton. So he's just popped in there the commentary of the court, paying attention to the questions of capacity at the time of instructions for a will are taken, and when the will is executed, where necessary, obtain an assessment of the client. And I think we all agree that we probably should have got an assessment of our will maker. Client should be interviewed alone, absolutely. And the solicitor should always consider capacity and the possibility of undue influence, if only to dismiss it in most cases. Yep. Great. So yeah, have a look at Ryan and Dalton. Tobin and Ezekiel, that's how you say it. That's a pretty good and fairly recent case regarding like suspicious circumstances, lack of knowledge and approval. So maybe have a look at that one if you haven't already. Great. So I think if we were solicitors in this case, we would have approached this in a slightly more thorough manner. I saw a comment in the chat too that $220 is a pretty cheap will, and yes, it is. It's a very cheap will. But look what we got. A will full of problems.
Actually, Arabella, you can get a will kit from the post office these days.
Yes. And I have to say, they are often the wills that keep me busy.
Yes.
Is that right?
do not recommend whatsoever.
I can give you a gag about my will if you like. When I was 18, going over to Kuwait, sitting on board HMAS Perth, the rabbi came out with a bunch of clipboards. You filled it out, filled in the blanks, signed the bottom, handed it to the guy next to you, he signed it, handed it back to the rabbi. That was it.
That was it.
That was it. That was my will. Give it everything to mum and da-da-da. Yeah, sign that. Thanks, coming. Well, because when you're 18, you're bulletproof and everything.
Of course.
We had a matter where one of those wills were done. So like it was like a post office will, and then the will ended up getting contested, but one of the witnesses was some random person, and we could not track down that witness. And it was an absolute mission and a half.
Yes, they're unfortunately, I think sometimes people prepare simple wills at home, thinking that it would be cheaper and easier for everyone. And that's where you find the biggest disputes arise from, unfortunately. Very costly and very difficult matters to run generally. Ian, sorry, I think you've had your hand up for a little while. Nope. Okay. Harry?
Yeah, just one thing about doing it over the phone. As says legal aid here, Victorian legal aid, the witness must also sign the will either when you are present or remotely using audio visual link.
Yeah, okay. Yeah, so the audio visual link, that's a really interesting sort of, yeah, it can be really interesting, wills that have been witnessed by audio visual link. I've had some experience, particularly in Victoria, when sort of the legislation changed to allow for audio visual witnessing of wills. And I also know that there have been some issues around the interpretation of, I guess, the steps that had to be taken for an audio-visual witnessed will to be a valid will. But I think that in those cases, the court recognised that it was a very, the legislation I think was quite quickly pushed through. Really, we needed something. We couldn't have people not signing their wills. So I think there's specific provisions for a will to be admitted ultimately as an informal will, but it's admitted as an informal will because of the audio-visual witnessing requirements maybe not being complied with, but it's a much simpler process than how you would ordinarily admit an informal will, because the legislation was so new, and there was some questions around exactly how to comply with that legislation. But I know that certainly at my firm, we have admitted audio visually witnessed wills to probate, both as informal wills and as valid wills. Yeah, so it can work, but I think in that case, you'd want to be, it's audio visual, so you can see the person. It's better than taking instructions just purely over the telephone. But I do still think that there's an element of that sort of interpersonal relationship and sort of nuanced behavior that you pick up perhaps a little bit more when it's that one-on-one in a room together type of appointment. But yeah, audiovisual witnessing wills do exist, and it's an option. Yeah. Ian? Sorry, I went on a rant there, didn't I?
No, that's good. I remember I was going to ask, how forthcoming is the Queensland Law Society if you were to make inquiries about the accreditation of the other solicitor, or whether he's had any complaints or anything? Do you have to get away for that, or?
That's a good question. I will say, and this could just be my view, I am very, very, very reluctant to make those types of inquiries, because put it this way, unless you're dealing with perhaps a set of circumstances that lend itself to maybe professional misconduct or negligence, you wouldn't, I wouldn't go looking at a solicitor's sort of records or background, just in circumstances where perhaps this behaviour and the steps that they took weren't best practice. I mean, where a solicitor is found to have engaged in professional misconduct or negligence, those cases usually are reported, so you can find out. You can check the role, the solicitor's role, online, but it's not common practice to, I guess, make inquiries about their standing, I guess, with the Law Society. And look, in some cases, I guess, if complaints have been made but not substantiated, that's not information that would be sort of readily available or disclosed, I would imagine. Yeah.
Yeah, no, I was just thinking you'd sort of have an obligation, wouldn't you, as an officer of the court, to report it, or you wait for the court to do it?
So look, in this case, you may advise, so potentially we could advise Jill to make a complaint to the Legal Services Commissioner that this solicitor's conduct has sort of fallen below standards. Because look, there are, and look, you'll see it in some of the cases as well. There are, there's the solicitor's duties, and sort of certain standards that solicitors are held to, and best practice that they should be, best practices that they should be adopting So you'll see the court talking about that. And so, like, for example, in this case, it would have been prudent, you know someone's in hospital, you know they're unwell. A solicitor really should be seeing that person in person, not, if instructions were provided by Trevor or the beneficiary in the room, if that was how the instructions were conveyed to the solicitor and the solicitor accepted those instructions, I mean, the court would look quite poorly on that solicitor's choices. They wouldn't necessarily reprimand them in those proceedings, but it could potentially be ground for disciplinary action. But again, it's not something that solicitors themselves usually do unless it's such gross negligence that you're obligated to report it or take steps.
So if you filed a caveat in the Supreme Court, I mean, do they argue that out there? I mean, is he called to give evidence in response to the caveat or not?
Let's not jump into caveats just yet because we will touch on them a little bit later. But just briefly, the solicitor that prepared the will may be required and would usually be required to provide evidence if the matter were to proceed to a trial. Yeah.
Okay, thank you.
No worries. All right, guys, we're at 6:56. So any other questions or comments before we close off for today? I think we've had a really good discussion today. Everyone's clearly put a lot of effort and thought into this. So well done. This is not an easy area, I have to say. So if you do have any other questions, let me know. This is probably one of those areas where I'll sound like a broken record again, but do have a look at some of these cases. It really will help with your understanding, and it will also show I guess demonstrate the requirements of a solicitor as well and how the court considers the evidence and what's required. So I do encourage you to read these cases, even if you just choose one or two. Just double check the chat, sorry. You've neglected that for a little bit. Nope, I think we're good. All right. Well, if we don't have any other questions, we'll wrap that up. But if you do think of anything after, reach out. We do have the forums as well. And I look forward to seeing you all next week. Thanks, guys.
Thanks, Sarah.
See you later.
See you next week.